because Sirius XM radio is actually, it's an audio company that's for our audio business is primarily in the US. There is also a Canadian version of the audio product, but we also have 5 other brands that operate in different parts of the world. And in order to be able to coordinate the receipt and the consistency and keep an auditable tracking tool, maintain the timelines that are necessary for data subject requests under the various laws around the world. That was absolutely one of the first things that just screamed operationalization, so that we had visibility, reporting, auditability, and consistency.
Was there anything that tripped you up when you were thinking of it? You said, we never thought of this. Was there anything when you looked through it, you said, why don't we look at this?
I think one of the most important characteristics that we looked for, I don't know if we tripped over it much, but that we definitely looked for and found to be very useful was the ability to customize to our business across any of the different, because as I mentioned, we have lots of businesses and they take in data in different ways, and they take in the customer experience, the customer registration, and how we recognize our customer is different on the different brands. So we needed the ability to customize that process because there was no out-of-the-box solution that was going to be readily available for us.
That's a fascinating thought to think about the different amounts of data and the different types of data and the different business units. So I love that. Wayne, you did this for hundreds of companies from the law firm point of view, and then you did it for a global bank. Both from a law firm point of view and from a client point of view, what parts of I'm going to ask you the same question. What parts of the process did you and your team think should be automated? Why? And I'm going to ask you another question because you've seen it this way. What parts would you have wanted to have automated, right? Not just what you did and why, but what would you, in your best possible thing, what would be the best thing to be automated as well?
All right, I'm going to go back on the question slightly. You're using the word automated, and that's not a word I'd use. What I would say is, what parts of the practice should you have digital assistance with? Because to me, what you have are a lot of users and a lot of processes, and they're hard to control, and they're hard to get your hands around just what they are and what they do. And what you need to unfortunately do is herd cats. And the question becomes, once you've herded the cats, what do you do with all that information? So when you say automated, let's talk about the GDPR and records of processing activities. It's not automated in that there isn't a machine that sniffs what activities you're doing and puts it into a record. But you need to have that record. And in order to get that record, people have to have a place to put that record. Otherwise, you're going to have a big pile of documents. So if I use the word automated as systematized or computer enhanced or computer assisted, then I'd say to you that I want to quote unquote automate as much as is possible. Because by automating, not only do I have a copy, I also have a backup, and I also have an audit trail. And an audit trail is fairly important because if you're ever audited by a regulator or some accounting firm wants to see that your systems are under control, you can show that you've done what you needed to do when you said you did. And there's some background noise, by the way, somewhere.
That could be me.
So, well, I'll come to you, Derek. I mean, you have an interesting role as, a longtime consultant and helping lead, but also chairman of the RMA in Canada. So you're trying to think about the industry as well as trying to help your clients. Same question to you, but Wayne has corrected me. We're not talking about automating. We're talking about digitizing or using using Hal to help you instead of using Hal to lock you out of the airlock. How about we say it that way, Derek?
Yeah, it's interesting because I'm seeing, I'm getting some feedback. So maybe when we're not speaking, we can mute. I think as I've come at automation or digital assistance, as Wayne would put it, I've seen a lot of stuff that's, it looks good when you say it fast, but it doesn't actually accomplish anything within implementing a privacy management program. And one of the things I loved about your vision with Safeguard Privacy when I first discovered it was it's actually useful to somebody, because oftentimes a client can't get their hands around, what do I need to do? And you've done an amazing job of breaking down the questions such that if you just answer the questions, you can get a compliance score. So you know where you stand, like for real. How many clients I've talked to who swore up and down when I started to deal with them that they were CASL compliant with our anti-spam law. And when all I had to do was peel it back a small bit, Richie, and they were not even close. And one of the things I love about Safeguard Privacy is it'll tell you the truth. There's a couple of others out there that we have absolutely embraced and love. One of them is Serenus, which is a consent management platform. How do you track all this consent? And how do you know who gives you consent for what? And I love Serenus with Cassie because they do that really well. And there's another one on the West Coast of the US that is starting to use AI to track contracts. And they're able to use the AI to measure whether you're doing that. So if you have a contract with Cisco that says you can do these 5 things and you're doing 7 things, this software will tell you, or this digital assistant will tell you that you got a gap and you have to look into this. Now that's operationalizing and implementing privacy, not just talking about it and off the cuff saying, we're compliant, because we use XYZ platform. It's I love the reality check that you guys have put into Safeguard Privacy.
So I appreciate the shout out. I don't want to sell our product here, but thank you very much, Derek. So I'm going to ask you 2 follow-up questions. One is, I'm sensing from all 3 of you that these laws are very complicated. And what I heard from you, Derek, is when you start just asking questions of your clients where people may think they're compliant, it's very nuanced and it's very hard to actually be compliant. Is that what you were saying? That's my first question back to you, Derek.
Absolutely. Because I'll use this as an example, Richie, having consent is quite different than proving consent. And these laws require you to prove it. Like Wayne said, the ROPA involved in the GDPR and in Quebec's Bill 64, there is a long list of business obligations that have to be documented. So that when the investigator comes in order to enforce the law, they can see whether you have policies and procedures. They can see whether you've done a privacy impact assessment because it's in writing, it's documented. And I think that, yeah. So hopefully that answers your question.
I'm gonna ask a question not on script, so hopefully I don't throw you guys. You said something interesting, Derek. I'm wondering, because most of these, the GDPR went into effect not that long ago. CCPA, CPRA is going to affect. All the other US laws. Quebec 64 is going to effect on September 22nd in a 3-year rollout. Are we like InfoSec 15 to 20 years ago? Is part of the question about automation that we're at privacy 1.0 and we're just starting to see the privacy 3.0 companies come out? I mean, Kaaren, are we looking at it's going to improve greatly because this is so new? I mean, 15 years ago, there wasn't a CISO. And when you looked at InfoSec, there wasn't a lot of digital assistance. Should we be letting our audience and the people that come watch this know it's okay, stuff is going to continue to get better, Kaaren?
I think always stuff gets better. I think that's generally the path. But I do agree that we have moved from a place where we had an omnibus law in Europe that sort of hit the screen and everybody scrambled, including the vendor support. Everyone was scrambling. In the 4 years since GDPR went into effect, and then California layered on, and Canada's layering on, and more states are layering on in the US. In those ensuing years, I think everyone's learned. Companies have learned what data they have, what data they use. They've learned it in response to what the legislation has sort of required them to learn, but they've learned. And in managing that, I think they've learned what to ask for. And I know that in choosing partners and tools and applications that we want to work with, the ones that Sirius likes to use are the ones that we can have a dialogue with and say, hey, we're looking for this. We want this. Can you help us with this? This is a need we see. Because I think that the industry and the legislation and the governance are all evolving together. And that's necessary. Where it'll be 10 years from now, I don't know. It kind of depends. Will the US pass a federal law? Will the rest of the world step up in a certain way? I can't. I wish I had a crystal ball. It would make my life so much easier. But the benefits and the ways in which we can begin to work with not just data governance, but compliance and data governance. They're two different matters, and I think both of them are necessary. I think we're farther ahead on compliance than we are on operationalizing data governance. It's a much more complex issue when you have, when you're talking about context of use and things like that. It's not as easy to plug it into zeros and ones. But I think we're headed there too. At least I certainly hope we are, because I'm looking for good data governance tools.
Yes, you took us right into your internal process. So it sounds like you want to make sure that whatever the processes that you use from the outside can be customizable, can be configurable, and are a living, breathing platform versus, hey, here's this thing, you just got to fit it in the box. And that's really coming from the fact that, look, we know that there may not be federal here in the US. There may be another 22 states. We've got Quebec 64. There could be other provinces in Canada. There could be a Canada federal law. All these things, it's such a shifting landscape, Kaaren. How do you put that into your internal processes to make good decisions when it's open, right? I mean, that must make the decision-making really hard for you internally.
Job security, I think. It helps to love the field. I have to say, I really love privacy. I'm really fascinated by it. So it helps because you spend a lot of time, understanding, looking at trends, looking towards the future to the best we can. And I actually think that's a very important part of the internal process is, as Wayne Gretzky used to say, don't look where the puck is, look where the puck is going. And you have to be that way. You have to address the compliance of today while you're keeping an eye on what's going to happen next. Any one of three things, but you sort of have to be prepared, and you have to keep your organization ready and nimble. So internally, I think the best way to manage the process for me internally is constant education to the business teams, constantly letting them know where we are, what I'm seeing coming up next, and how might that impact our business. And then from a management perspective of the privacy compliance side, it's maintaining that internal partnership with the business teams, because I'm going to need them to respond fairly quickly. Luckily, so far, most of the laws have given us runway. But California isn't helping, particularly right now, by kind of hanging on the regulations, right, where we don't know exactly what the implementation is going to come. So you just have to stay, alert and nimble. And you have to have suppliers, vendors, tools, and partners who will also be nimble.
Eric, I just want to point out that Kaaren just shamed you. Not only did she get hockey and she got the great one, and she got, skate where the puck is going to. So you're in the box right now for 5 minutes.
I loved it. Yeah. As you were speaking, Kaaren, I wrote down progress, not perfection. I don't think any of us are going to get privacy right out of the gate, but we can start making progress towards it. And every year, I believe a proper privacy management program should get better and better and better. And I love your comment about communicating with the internal teams, because privacy has to be central to organizations.
Wayne, let's talk about global orgs, because I know there's a lot of people on here and people will be tuning in. Yes, we are focusing on Quebec 64, but if you're dealing with a multi-regional, multi-business line, multi-product, and you're global, how do you do it? Do you start instead of global? And I'm going to come to you, Kaaren, on this after. I mean, Wayne, you did it for a global bank. Did you pick a global standard and then you broke it down region by region? How do you think about that? How should companies, what do you think the best practice is to think about that type of problem?
All right, that's certainly an all-day webinar. Let's try and find a logical place to start. First, I was one of 4 individuals responsible for data governance for UBS globally. And so what you've asked me to do is my job description. How do you do it with focusing a little bit on the privacy side of it? First things first, you need to divide the world temporally into what is and what will be. And what I mean by that is there are things that were built in the 70s and 80s that are still working today. And they're still functioning, and they were not built with the view that there would be privacy laws or rules in place, let alone data security. And so you need to put in a box what I have. And then you need to start dealing with the issue of what will the future be like. And so the very first order of business is getting control of the future. And the reason that I say that is there's always a regulator looking over your shoulder. And the regulator might be forgiving about what you did in 1975 when you weren't even with your company at that point. But what you're doing in 2020 and 21 and 22 and 23, they're not going to be so forgiving about. And so order of business number 1, have an onboarding process. Make sure that whatever you're building meets with whatever the rules are that are applicable to it. Number 2, start going back and looking at and approach this from the viewpoint of a data protection impact assessment. What are my systems that are the most vulnerable? What are my systems that are the most sensitive? Which ones are using the most dangerous, pernicious, pick a word, data? Which ones are the processes that are the most sensitive? And do a list that effectively categorizes things from 1 to 5, and then start at the top and work your way down. So you have 2 work streams. One is an onboarding stream, and the other is a remedial stream. You asked about global versus local. Again, interesting question, and the answer to that would change over time. A couple of years ago, you'd probably say, deal with Europe first. Now, you probably do have to deal with Europe first because it's a little bit more mature, but Canada's getting active. California is getting active. They're getting active in Mexico and Singapore, and so is China. And so for my part, I still believe in a regional approach with global standards. I think that you have to take a look at where the regulatory activity is. And you need to effectively, where do you put triage? Where do you put the emergency room? It's where the ambulance are. So figure out where your risks are and start approaching things on the basis of risk. And frankly speaking, everything I just said was approaching on the nature of risk. What you're onboarding, that's the riskiest. What you have with the most sensitive data, that's the next riskiest. Where there is regulatory activity, that heightens what is the most risky. Those are the criteria that I would look at.
There's an awful lot to unpack in that, and I appreciate you putting in a whole day into about 10 minutes. So I didn't mean to put you on the spot, but that really is helpful. Kaaren, do you have anything to add to that? How do you think about that as well? Because you've got all these products around the globe.
I like very much what Wayne said about looking at things through a risk-based lens. I think that there's, if you're just coming onto the scene, there's so much to do right away that you have to prioritize, and risk is the best lens for prioritization. I also would echo what Wayne said about assessing regulatory activity and regulatory sensitivity. You can see where certain data protection authorities are placing their weight. What's their main significant set of activities? Is it targeted advertising? Is it financial? Is it information around children? There are significant hot buttons that are emerging in the various legislative environments. Is it consent? Is it affirmative consent or opt-in consent? So you have to be aware, how does your business rely or fit into that particular regulatory sensitivity? And that, to Wayne's point, that heightens the risk, but it also heightens your intersection with that compliance. So the requirements are going to be more significant for you in those areas if that's the main core area of your business or something like that. So I think you have to, you can read the statute. That's the first thing to do, and then and make your checklists, or use an application to help you assess. But then you've got to sit down with it and say, okay, so which of these pieces is the most critical for me to address first? And that could be territorial, or it could just be based on your industry, your business process, or your line of business, and what's critical to your model.
So I heard something really interesting there, and I have a question follow-up for you, and then Derek, I have a follow-up for you. So I think I heard you say you really need to do a gap analysis of these laws, right? And see where your problems are, and then cross that with your, I don't know the right word, Kaaren, cross that with your assessment of what you're hearing, where the regulatory is going, what they're saying about what they care about. And then my question to you is, does that help you if you're compliant with one region's laws, but not with another? Or do you have to, I'm asking a terrible question here, Kaaren. I feel like you're saying that we need to do a gap analysis, but then how does that help you if you're compliant with one region, but you're not compliant with the other? How do you handle that?
I think if the gap is showing up in an area that's critical to your business, then it needs to be raised up on the priority list. I assume that you won't do an assessment against territories that are not meaningful to you, because that won't produce anything that's useful. So you can sort of carve out those parts of the world. And then I guess, in addition to looking at what's where the pressure is going to be applied, or the bright light might shine on your business, for example, between two very significant gaps in some place, then maybe you would also then go to what's the fallout. what's the brand damage? What's the penalties? And then place that one higher than the other one. But ultimately, you're going to place both of them very high if they're both parts of critical business. So you just have to prioritize. I mean, there's only so many resources in a company and only so many resources in the world.
Well, let me ask it a different way. Let's say you as an entity, whoever that entity is, got fully compliant with GDPR. Do you think that's going to help you in the rest of the world if you make a really strong effort on GDPR? Will that give you a good baseline?
Yes, but I think you can't rest on it. You can't just say, hey, I'm GDPR compliant, I'm good. There's too much variation now in the landscape. I mean, even within the US, there's too much variation to even say I comply with California and therefore I'm good. So, in 2023, we have 2 state laws that are, one has an opt-in for the collection of sensitive personal information and the other one has an opt-out for sensitive personal information. That's, diametrically opposed, sort of. So you can't, you really do have to know where your territory is and understand what the laws are in those spaces. If you operate absolutely around the world, GDPR will give you a very, very strong position in most places, sort of outside the US, Canada, and obviously it will cover EU and UK. But if you have a heavy presence in China, I would say look really, really closely at the new Chinese law.
That's fascinating when your example of the US, especially with the frictionless e-commerce, you can sell a product in every state and you've got an opt-in and opt-out. That's going to be a nightmare for people to think through.
Well, luckily, that's only limited to certain kinds of information. That's to the sensitive personal information, which is a very, very narrow category. But nonetheless, an important one if it happens to be important to your business.
Yep. Derek, Kaaren said something very important as well. Regulars, and I apologize, I'm going to catch you out here. I don't mean to. COPPA, children's privacy is really important. COPPA has been around for 10 plus years. California has just passed a really strong children's law, which we haven't gotten our hands around yet. Does Canada have the same type of thing in any of their privacy bills, Derek? Because I apologize for not knowing it, but it just popped into my head with Kaaren talking about what do regulators care about. I think it's clear that they care about children.
Absolutely. The problem with our federal law here in Canada, which is PIPEDA, is it's not enforced. It's got a very low threshold. So it's really a set of best practices for companies to, take guidance from. We're in the changeover now of enforced laws. So the new Quebec one did not take that position. So what we recommend to our clients, regarding what Kaaren just outlined, is if you're global, pick the toughest law globally and try to comply to that, and you're going to be good. And then you, what I call, trim around the edges. So obviously, if you're doing business in California, you need to add the "Do Not Sell My Data" button. And there's probably a couple of other little nuances, but fundamentally, if you're GDPR compliant, you're going to be 95% of the way there against PPI-APS in Quebec, for example. Quebec has a couple of little things that they did that are absolutely fascinating to me. They actually put the highest authority in the organization in charge of the personal information that company holds.
I saw that in your write-up, and it could be the CEO, but they can delegate it, right? So
they can,
if I was,
but they're always accountable, Richie. They're always accountable. That's the key.
So while they can delegate, so this kind of has echoes of, remember when SOC compliance came in the US, the CEO and the CFO had to sign, and that rolled downhill pretty quickly to everybody. So when you make the CEO accountable, so I just want to clear that up, Derek. They can, for Quebec 64, if I'm the CEO of Richie's, cookies and soda, and Kaaren is my chief privacy officer, I can delegate it to her, but I still am legally responsible?
Yes, and all policies and procedures you actually have to approve. So before it becomes the policy of the company, the highest authority has to approve it.
I think that's a game changer. I mean, Wayne, what do you
It is
think?
a game changer. It's what was missing from the GDPR.
Wayne, what do you
The
think?
hardest part of enforcing GDPR, from what I'm told by the insiders, is the fact that the C-suite isn't paying attention to privacy at the level they should be. And if they were, things would be different. So Quebec took that information and said, okay, we're going to actually be prescriptive and say that the highest authority in the enterprise is accountable for this act being complied with. That's pretty heavy. And yes, you're absolutely right, Richie. They can delegate to inside or outside people. So,
Wayne, you're on mute, but I would love your, with all the think tank stuff you do, I love your thought on that. Is that something that you think should be?
I would add to what Derek said. And to restate so that I'm accurate, and basically tune people into my thinking. Derek effectively said that one possible approach is dealing principally with your home base. And if you're a Canadian company, dealing principally with Canada, I'll buy that. That is certainly one approach. If you are heavily located in one country and everything else is, if you're a citizen of the world with major offices in 5 countries, that doesn't work. If on the other hand, you're 75% Canada, yeah, that's a valid approach. But the way I would then look at it, or what I would add to it, is similar to the fact, Richie, that you live in Southern New York and you have a second home on the Canadian border. When you drive up there at 100 miles an hour, you actually know there are a couple of spots where the state troopers are, and I'm willing to bet that even you slow down. Now, you can say no and smile, but I bet you do. So if you're a Canadian company and you're dealing with Canadian law as you have to, and you're being really careful as you have to, I still would watch out for the speed traps. And so I would look at what the enforcement activity is. Where are the cops and where are they giving the tickets? And if I'm doing 5% or 10% of my sales in California, or if I have a sales office or distribution center there, I would immediately start taking a look at, kids, like you said. But I would also take a look at the recent Sephora decision, where you saw where the Attorney General is focusing. If you tell people you don't sell data, you better be telling the truth. If you're selling data, you better be telling people that you're selling it and where you're selling it to. If you have service providers in California, you better have those contracts in place. In other words, I would look at where the regulatory activity is, wherever it is that I'm dealing with, because there's a cop sitting with a speed trap someplace, and you don't want to be getting the ticket. Is that perfect? No, it's not. Do you have infinite resources? No, you don't. So you got to be smart in deploying them.
So Wayne, I want to have 2 follow-up questions. One, I mean, I think that's great advice. If you look at that, if you look at Sephora, you got to know what you're doing. Maybe somebody didn't know they were selling the data, but that's surprising to me. It seems like those are the easiest things for a regulator to look at. Contracts with your counterparties. And are those contracts correct? And are you doing what you said you're doing? So that's what I'm hearing you say. And then I'm going to ask you another follow-up. Is that the point you were making?
Make sure that whatever policies that you have out there comply with whatever the local rules are where you are. To not have a notice of a certain kind when notice is required, it's really easy to write you a ticket for that, isn't it? And if you're making representations, make them truthful. Don't say something that's a lie. Understand how, for those who aren't familiar with United States law, the Federal Trade Commission has extremely limited authority. It is able to go after unfair business practices. What is the easiest thing that's unfair? When you lie. So if you're going to make a statement, the federal government has the ability to go after you if you lie. Better to say nothing. They can't go after you if you say nothing. You didn't lie, unless they have the theory, which is to say, by not saying something, you were misleading people, which is a difficult theory. It can happen in some circumstances, but it's a much harder burden. So be very careful that you're truthful in what you say.
Wayne, let's focus. This was the California AG, not the FTC. With Sephora, they didn't do what they were saying they were doing, right? If they had just said we're selling our data, they wouldn't have got the fine, right? If they were upfront about what they were doing with the data, they wouldn't have gotten in trouble. You can sell the data, they just weren't.
Look, there were other violations, but I don't think that they would have. I don't think the speed trap would have caught them if they hadn't done what they did. The rest of that was tacked on because of it. They didn't enter into contracts with their service providers. Those are required contracts. There are thousands of companies out there that haven't done their required contracts. They got the extra ticket for that because they sped.
Okay, let me get one quick question, then I'm going to go to Kaaren with this exact same question so she can think about it. Going back to Quebec 64 and the fact that the highest level of the person, so let's give a real example. The CEO of Rogers is responsible. Rogers is telecom, they've got a big businesses, they got a lot of data with people, their television, their cell phones, everything. They can delegate it to their chief privacy officer, but if it screws up, that person's responsible. If the GDPR or if CCPA or any of these other laws around the world made the chief or the highest person in an organization responsible, do you think people would think differently about privacy the way the new Quebec 64 is set up?
Richie, I don't know of any CEOs that have gone to jail or received substantial fines for violating any law where the chief officer is responsible, with the exception of fraud. So if you're Enron, yeah, okay, you're going. But other than that, making the chief officer responsible, I do think it's a little bit lipstick on a pig. What it does do is it forces the attention at the board level, and it has the effect of getting organizations to be more serious. And the chief executive officer feels vulnerable and maybe a little bit vulnerable if they're derelict. So it does push them to do what they need to do.
I am going to predict, Wayne, that some of the first fines coming from the guy in Quebec will be not to the company, but to the executive. So
Yeah,
we did it under Castle. Individuals were fined for spamming, not the companies. And I think that that's where Quebec is going to go. And that's just a gut feel. Why else put that in, right?
Well, let me say this to you, Derek. If it happens, that will be the greatest motivator for compliance that could occur.
All right, let me let Kaaren in here. Kaaren, you've been doing privacy for as long as anybody out there, and you've been doing it for clients this whole time. What do you think if they made, and of course they're not going to go to jail, Wayne, what do you think if they held people responsible? You think people would change their attitude towards privacy?
I think that's shifting already. I think, yes, of course, if you codify it into law, it just, it makes it harder for someone to look the other way, right? If they ever intended to in the first place. And it does put it on their radar as one item that needs to be viewed and addressed. I think what I have seen, and it's already been as much a part of sort of the SEC filings and world is that privacy starts to become, information has risen to the level of being something that must be reported on a 10K, or any other kind of risk filing, right? So where there's more legislation, there's more risk of potential litigation, there's more risk of potential, exposure. The damage, depending on what you're doing, the damage may or may not be clear or quantifiable right away to be able to talk about, stock price moving. But all of those things place it at the level of, the highest C-suite and eventually the board. That lifts it up to the level of, some sort of information security and privacy presentation to at the board level. If there's risk involved. If there's no risk, then they don't necessarily need to be presented at the board level. But I do think that putting it into a legal format and placing an individual officer as responsible, yes, it heightens the attention. It heightens that bright light that I was talking about before. Whenever the bright light shines somewhere, everybody in the light gets a little nervous. Yeah. So I think it's happening because privacy is in the news, because privacy fines are bigger. The Sephora fine's pretty good size, right? Nobody wants to be in an FTC action, so there's a lot of focus on right now. It's a very consumer friendly and very aggressive FTC right now. So there's a lot of focus, a lot of enforcement actions are being discussed, if not actually sent out. And I think, I think that privacy is coming of age, if you want to call it that.
Reputational risk is not great. Wayne, what did you want?
I just want to remind people, if they were in privacy at the time, and if not, it's relevant. Back in 2006, Google allowed videos of a child who is autistic on their network, YouTube. It got a lot of play. Kid was cyberbullied, bad things happened. 3 Google executives were tried in Italy and they were convicted. Their jail sentences ended up being suspended. Did that have an effect? Yes. Did anyone go to jail? No. My point is, you have to my knowledge, go all the way back to 2012 to find an example, even though laws have been on the books like this in Europe for a long, long time. So to me, I'll believe it when I see it.
It's interesting. I do think reputational and brand risk is a big issue today.
That, Richie, to me, is the bigger issue. Everybody knows that Marriott had a security breach. Everybody that checks into a Marriott thinks about that every time they pull out their credit card. That has an effect.
Yeah, I think that's a big issue. You don't want to be the company in the pickle barrel. You don't want to be the one that's, even though the press cycle happens so quickly, I still think, my gut feeling tells me it's just good basic business hygiene not to be the one called out. I mean,
Richie, can I ask Eric a question? Yeah. What I found interesting about the Sephora case in California is California picked on a French company. And so my question to you is Quebec going to go after an American company first?
I think they're going to go after companies outside of Quebec who are using a Quebec citizens' data, personal data. So whether that's American or other Canadian companies based in Toronto, for example, I think they're going to be a little more reticent of making an example out of the big companies like Desjardins that are Quebec based, or Air Canada. I think they're going to be a little more lenient with the big Quebec corporate players and a little tougher on outsiders, which would be other companies operating in other parts of Ontario, of Canada or US. So yeah, if a company is doing a lot of business in Quebec with Quebecers, they should definitely have a heightened awareness. But the thing about the Sephora one that really struck me was the interpretation of selling. Were they selling by their standard? They were maybe being too cute by half, but by their standard, they weren't selling data. But by the way it was written in CCPA and CPRA, they were, because they were getting something in return. And although it wasn't cash, it was something. And therefore, the AG wanted to make sure that he made an example of them, that you don't have to be selling it and actually have an invoice and get paid, but you're getting something back in return. That's what the AG considers selling or selling.
I think, Derek, that's one of the biggest issues of why we have CPRA, CCPA. Kaaren, is there anything you wanted to comment on that? I saw you nodding along with that. I think that's going to be one of the biggest trip up items, right, Kaaren? Are you selling the data? Sharing the data is now selling the data. Is that going to be a problem for people?
I actually think with the addition of share in the context of cross-context behavioral advertising, that it becomes a little clearer, because I think before it was sort of, is this a share? Is this a sale? Is this, sort of all those kinds of parameters. The California law has got a lot of it's got a lot of nuance and unclear nuance. The original one was rushed out the door. It's full of gaps. It's full of internal contradictions. CPRA has resolved some of those contradictions, but created some new areas of uncertainty and ambiguity. So to Derek's point earlier, privacy in the world today is not about perfection, because there's no such thing. It's about progress. It's about trying to be respectful of a consumer's rights under the law. And I will say, I was nodding, and I was thinking about, while we were talking about these other issues, is that consumers today, I don't know if they would have felt this way if you asked them this 20 or 30 years ago, but consumers today feel that they have a fundamental right to privacy. They feel that, whether it's codified in their state or in their jurisdiction or not, this sort of expectation that they have a fundamental right to privacy. But the devil's in the details, because it's, what does that mean? What is, each of them sort of has their own view of what their fundamental right is, and so and the laws don't help, because they're not uniform or consistent in terms of what they're granting as a right. So perfection is always going to be pretty much out of reach for a while, and the courts will give us guidance as they come along. I don't recommend that we step up to be the source of that guidance, but so you have to do the best that you can to literally try to do the best you can, and to document your decision process. I would say that's one of the most important things, is you document your rationale.
That is a great, I really appreciate that. Derek, we got 5 minutes left. What are the Canadian companies that are on this webinar need to think about? What's fast approaching for Canada? What are the action items we need people to do?
Yeah, Quebec did something I think very clever. They came into force in 3 stages. So next week, September 22nd, is the first stage of coming into force. And it includes your privacy governance framework. So documenting, as Kaaren just said, putting it in writing, that your CEO or the highest authority in the company is responsible, but is delegating to this person or this role. So that all has to be documented. Then the second piece is a full head-on, what they're calling confidentiality incident reporting plan. We used to know it as security breach reporting, And they've included data security and privacy breaches all under the one term called confidentiality incidents. And it is in the law of PIPEDA. It was introduced in November 2018, that confidentiality or privacy breaches had to be reported, especially if they could result in significant harm to the individuals involved. So they've set some pretty good guidelines. They put out draft guidelines a few weeks ago, which gives us exactly what they're looking for. So there's going to be no excuse. Next September, when the CHI gets their powers to enforce, they're going to be able to reach back to this September and fine companies for not having breach reporting or confidentiality incident reporting in place. So
that look back window is really important.
it is. It is. So we're coaching our clients to, by the end of September, have that in place. It's not that difficult to do, and it's the first couple of pieces, and then we'll start looking at the rest of the pieces. But you know, back to something you said earlier, it all starts with that privacy review. If you don't understand what's so already, it's hard to fix anything. It's hard to get your hands on the levers and the dials unless you understand where the data is, what data is being kept, what practices are in place. So yeah, that's where I would start. I would start with a sound privacy review and a gap report, and then pick the most prioritize the most pressing things.
So Derek, your advice is do that assessment, do the gap analysis, start now, right?
Yeah, get in motion for sure.
Wayne, any final thoughts? And then we're gonna let Kaaren wrap us up.
No, not for me. I thank you. This has been a very good discussion.
Hold on, Wayne, any final thoughts from you? Wayne, you're on mute. Sorry, bud. It's the great webinar.
I am waiting for Kaaren to wrap it up.
All right, Kaaren, I love what you actually did our wrap up earlier, which was, I wrote it furiously down. I thought it was incredible. One of the reasons Wayne and I built this company is we actually agree with you 100%. We believe that consumers want that fundamental right to privacy, and we're trying to help the industry. So I really appreciate you bringing that up. And your first comment, I love this, to get into it, because it is not easy, is it, Kaaren?
It's a lot. It comes at you as a fire hose, right? Sometimes. I mean, in wrap up, I'd say, yeah, that I think there has to be a fundamental shift in the direction that the way business looks at its relationships with customers and consumers and prospects and employees. And that is around the fact that, you know, where businesses used to talk about our data, and it really is not so much our data anymore, as it's, you know, we're stewards of the data. We have use rights to the data. The consumer is in a position, you know, and ever gaining a position of control over the information that they share with us as a business. And it's a mind shift. And I think that it's an important sort of foundational element for businesses to think about. And then to build on top of that, you know, the exact things that Derek was talking about. Where is the data? What do you do with the data? You know, what's the gap against the places that we operate? What are our most important areas of risk and areas of consumer expectation? And then build it out from there. Operationalize as much of it as you can, because it's only going to get more.
Right. I mean, Kaaren, you know, if we hear this from you and clients everywhere, what do you have? Where do you have it? What does it consist of? What's the risk? Can you change it? Can you fix it? Can you protect it? You know, all the basic building blocks. But then, I mean, I've heard from all three of you, read the laws, do a gap analysis of everything, comply where you need to comply, risk-based approach. And I think what all of you are saying is face it head on, face it now, don't kick that can down the road. Derek, was this helpful for the RMA and for the webinar? Is this?
Absolutely, absolutely. And if nothing else, if everybody takes that last comment away, Richie, that the can being kicked down the road is now. We're where the can got kicked to, and we got to start.
I
We
mean,
got to
Wayne
start somewhere.
has always taught me, and I've heard this from a lot of other people, a regular wants to see that you're trying,
Yes,
right? You
Yes.
just got to try. If
yes,
you say, I don't have a plan in place, I think, you know, a regulator wants to know, I've got this plan. Even if you just started to say, we're taking it seriously, we're just starting it, check with me in 30 days. I promise you, we're going to make progress and do it. They want to see that you're taking, you're believing them and taking their laws seriously. And I think
Yeah.
and I'm the only non-lawyer on the call, I think that's, as a business person, I think that's what you want to do, right?
I thank you, Kaaren, Wayne, and Richie. Thank you for your contribution today. We will be posting this on our website, on the RMA website, and chumming a lot of people to look at it because we covered a lot of good stuff here. So thank you very much.
Thank you, Derek. Thank you, Kaaren. Thank you, Wayne.